We'll get to the phone right now where we find Dave Zumpano from the Estate Planning Law Center. And Dave, good morning. Good to have you back on.
Top of the morning to you, gentlemen.
Good morning.
Yeah.
Good morning. Are those birds chirping?
Yeah, what are you doing?
They are birds chirping, yes. You know, it's so funny, it kind of gets immune to it, but every time I'm on a call, I forget and people pick it up.
So that,
a lot of people have the Zoom background. That could be like a sound background.
Yeah, I didn't know if that was audio that you're pumping in, Dave, for just theatrics there. So
You get,
well, you guys have birds chirping today, too, so that's a great thing.
Yes. Yeah, it is.
So these are virtual birds, or are they
these are
real birds?
These are authentic.
These are authentic birds. They might be native of a different state, I think, is what Dave might be getting to. But Dave, joining us here, the one time every month here, usually the last Tuesday, ends up being the fourth Tuesday usually of every month, and we talk about issues that you might be dealing with here with your estate planning, and we've covered quite a bit, Dave, over the last year, especially I think with coronavirus and a lot of those changes.
Dave, can you talk about? There's going to be a change in the power of attorney law coming up soon. Are you familiar with that? And can you talk a little bit about what the change is and how that would impact people who have an existing power of attorney?
Absolutely, I can. So. It's funny, the power of attorney, let's talk about that for a moment. What is it? We always talk about it. We know it's one of those essential documents. And the power of attorney is a document that authorizes someone else to make legal and financial decisions on your behalf. Now, many people confuse it with the healthcare proxy, which is a document that authorizes someone to do healthcare decisions for you. Two different documents. You need to authorize both separately. So that being said, the power of attorney, the document that authorizes someone to act for you legally and financially. A couple things to know about it. First of all, it is valid when it is signed. A lot of people don't realize this. They say, okay, I sign it. That way if my kids ever need it, they can have it. No, it is valid when it is signed. The second thing to know about it is it remains valid until you revoke it or until you die. So this is another very interesting thing about the power of attorney. A lot of people think, oh, well, if anything happens to me, my power of attorney will take care of it. Well, that's only if you're alive. Once you die, the power of attorney is no longer valid, and then we have to rely on your will to carry out wishes. So those are some basic essentials around the power of attorney. So who needs one? Well, everyone needs one in this context. If something were to happen and you were to become incapacitated, car accident, stroke, or any other thing, all assets you own or legal matters on your behalf kind of get locked up, and because you can't act on your own behalf. So the power of attorney authorizes someone else to act on your behalf. Now, on what matters? Well, it could be from matters of owning a business. It could be from matters of accessing, your bank accounts and paying your bills and things of that nature, and a whole myriad of other things. And that's what the power of attorney does. There's what's called the statutory short form power of attorney. And what that is, the government, the state puts out a form that says, okay, if you follow this basic format, this must be honored in the state of New York. Now, it doesn't require that you have to follow that format. So as long as you construct them, but 99.9% of powers of attorney follow the state format. Why? Well, when you have one that you know works, why mess around and do anything else? So that form, what we call the statutory short form power of attorney, every so often gets modified. Now, I think the last time it was modified, I'm going by memory, I want to say it was around 2012 or 13. Seems like about every 6 or 8 years they modify the form. This modification, though, I think is a really good one. The one they did about 8 or 10 years ago really was a disaster in this sense. It was complicated. It is one of the most complicated documents that I oversee people signing. It requires, first of all, initials to be done in multiple places. There's about a half a dozen to a dozen different choices you have to decide on an initial within the document. It requires it to be signed in front of a notary, and it has a statutory gift writer, and it also requires witnesses to the statutory gift writer, and a myriad of other things. It really, truly would take us longer to execute those than sometimes the will. what happened? Well, because of the complexities, it took them a number of years, but they revamped it. Now, in New York, when you create a new law, it takes some time to go in. So this will be effective June 1st. Now, the good news is all existing powers of attorney are still valid. They don't become invalid just because they change the form. And your existing ones still work. What do they do in the new one? The new one, they tried to simplify it. They eliminated the statutory gift writer. That was a whole other form that identified special powers above and beyond the regular ones, and that had to be signed in front of witnesses. So they have consolidated them and tried and streamlined a lot of the questions and shrunk it down about 30%, which is good, all a good thing. The good news is, like I said, your existing ones are not affected, and anyone executing a new one after January 1st, even if you execute the old ones, they're still valid. It's just probably easier.
Did you mean June 1st, Dave?
The new forms.
Did you mean June 1st?
June 1st, yeah.
You said January. I think you meant June. Yep.
Yeah. Did I say January?
You did. Yeah,
I'm
just
sorry. I
want to
meant
make sure.
June, yeah.
Yep, June. So the one thing that's interesting about this, I think, is under the current law, if you want to allow your power of attorney or your attorney in fact, sometimes it's called, to make gifts over $500 is a separate form that has to be signed and, as you said, witnessed. Under the new power of attorney, that additional step is eliminated, as I understand it. And so now you can give your power of attorney in the form itself the power to make substantial gifts. Is that what one of the big changes in this?
Yeah, I think, it's one of the things, the devil's in the details, right? So when we think, okay, that's great, I want my, power of attorney. Let me pause a second there. This is also one of the most confusing terms that they call this a power of attorney. And everybody thinks they're giving their power to me as the attorney. I'm like, no, this has nothing to do with me as the attorney. It's called your agent. They call him your power of attorney. But yes, as Mark says, when they did the original statutory gift writer, back in the early 2010s, they were trying to protect people from giving these blanket powers to allow their agents or their power of attorney to give away their money. Now, on the flip side, a lot of people want their agent to be able to give away their money if they want to, quote-unquote, protect it from a long-term care or other creditors or predators. So what they've done now is they have incorporated some of that statutory gift writer right into the healthcare proxy, but they're not longer, but have lowered the restrictions. In other words, eliminating the need for the witnesses. But the flip side of it is this: a couple things you need to know. Granting someone the right to give away your assets has a double-edged sword to it, right? While you're incapacitated, they might be giving your assets away. Now, the challenge is the power of attorney, by its terms, always say that the agent, the person acting on your behalf, must always be acting in your best interest. So they're not technically authorized to go give the money away to themselves or other people. This gift writer does authorize them to do it, but it usually should be tied to some kind of gift patterning or technique. So, for example, tithing with your church, or giving annual birthday gifts and holiday gifts to family members. Beyond that, again, you do run the risk that while you're incapacitated, people start giving away your money, maybe in unintended ways. So it's always a double-edged sword when they give these powers, to make sure they're not abused, and that's always why it's best. When you do look at the standard statutory forms, which you can get in stationery stores or online, which is another great question. Online documents, are they reliable and viable? They do give the basics. What they don't do is they don't give interpretation and guidance. And what I mean by that is this: these general documents really accommodate a vast majority of the basic things that go on. There are other things, though, that they don't cover. For example, the standard power of attorney does not grant access to safe deposit boxes. It doesn't authorize, really changing of beneficiary designations and things of that nature, because they didn't want to change testamentary intent. So there's a myriad of things that the statutory power of attorney does not do. And that's why, like, for example, in our office, we add a whole myriad of additional powers that typically are needed but are not provided in the underlying document. That's why the online document services, whether it's for your will or your power of attorney or healthcare proxy, they do provide the basic information. What they don't always do is provide the extra protections that might apply to a specific individual. For example, if you have a disabled family member or child, and you want those protections for that disabled, those are not generally covered in the standard or statutory documents, and myriad of other things. And so it's a double-edged sword. It's simple and it's easy sometimes. The new powers of attorney, again, it'll take them a little while to hit the stores, but they'll probably be up and running because there was a 6-month lead time. Mm-hmm. And so it's just another very important thing to keep up with the changing laws.
And Dave, I would mention something in the beginning. You said that people should be aware that you can't make health decisions with a power of attorney. It's confusing because in some states, they refer to what we call a healthcare proxy as a healthcare power of attorney. That's the term I think they use in Florida. So it can be confusing for people. In New York, we distinguish between the power of attorney, which, as you said, is for business decisions, financial decisions, and the healthcare proxy, which is for medical decisions. And neither one allows you to make decisions in the other arena. But in some states, what they call the healthcare power of attorney is actually the same as our healthcare proxy. So that sometimes I think is something people find confusing.
Well, Mark, you raise another question. I get this question all the time. If I create my power of attorney and my healthcare proxy in New York and I move to Carolina or Florida, is it still valid? And in theory, the answer is yes, under the full faith and credit. However, it is unknown, and therefore, if you walked into a bank, say in Florida or North Carolina, with a New York power of attorney, it would be foreign to them, and they wouldn't recognize it, and so they wouldn't accept it. And they would probably make it go to their legal department, and then their legal department would give you a lot of hassle because they don't really understand it because it's from a different state. So basically, while there is general acceptance, it's always good to get those documents updated when you get into another state. Healthcare proxies, I find, however, are much more universal because they're pretty standardized throughout the country, and they are generally accepted. Wills as well generally are accepted across the country. However, we always encourage you, if you were moving to New York State or moving out of New York State, to get those documents reviewed by an attorney in those states, just to make sure there's not any particular nuances with that state that apply to you. Generally speaking, the general basic documents are going to work for most people most of the time. As Mark and I could tell you, working in the law, we don't often get hired from people who are dealing with the things that happen most of the time. It's always the people that have the exceptions that say, I didn't know that applied to me. I didn't know that didn't work for me. And that's really where really getting that guidance and insight from attorneys do help you identify. That's why we do the workshops.
Yeah, that's what I was going to say, Dave. Before we run out of time here, I do want to make sure that you throw that in there as well. So you need further guidance, or maybe you have questions that apply to your situation specifically. You do. You provide those workshops, and then I know you'll speak to people as well about their individual situations, right?
Yeah, I think that's why we've done the workshops for over 20 years now. They're informative, they're free, and they tell you all the information you didn't even know you needed to know. Everybody comes in and say, I know my friend had this happen and that happened, and I can tell you what a nightmare that is, because there's a whole bunch of facts about your friends that you didn't know. You're just hearing bits and pieces. Right. That's why we do the workshops, really help people understand. No, hang on. Here's how it works. Understand it so you're not relying on the lawyer, so you understand yourself. And you can start to identify what issues are most important to you to protect against, because everyone is different.
Mm-hmm. So when do you do those workshops, and how can someone participate?
So we have them weekly, essentially. We also have them virtually. So whenever we're doing them live, you could come in by Zoom into those same meetings. Also, we are able to give you digital downloads to watch them at your leisure. So if you work the 3 to 11 shift and you want to wind down after you get home, you can watch it at midnight if you'd like. And so, again, we do that just to keep people informed, and they can find out that by going to eplawcenter.com, E like Echo, P like Papa, eplawcenter.com, or call the office at 3622.
I like it. You can wind down, throw on the bird sounds in the background, and it was a nice added touch this morning here, Dave. They were chirping during your talk.
I aim to please.
Yeah, there you go.
I'll be back with you in a couple days, though, to come up and enjoy whatever's coming in your weather pattern.
Yeah, well, it's not bad.
It's gonna be a little chilly.
It's been nice though, Dave. So
that's great.
when you get back up,
Next time, Dave, I want you to have your Zoom sound to be like chickens or
yeah,
something.
there you go.
Sound like you're on a farm. Cows mooing.
Yeah, I love
You'd be like, "Where's Waldo? Where's Dave this week?" All right,
Exactly.
Dave, we appreciate it. Dave Zumpano from the Estate Planning Law Center. We always appreciate talking to you, and we'll see you. Maybe we'll see you soon as well when you get back.
You might see me in studio next month.
I like it. Dave, thanks for joining us here this
Have
morning.
a great day, Jen.
You too.